hazard and the education right. Insurance on the fundamental right. The fundamental right that by the constitution are the interest by the public. Some of the available only to the citizen with other are the available to all the persons, whether the citizen, foreigners, or the legal persons like the corporation or the companies. They are not the absolute but the qualified. The state can impose reasonable registration of them. However, whether such the restriction or the responsible for or not is to be decided by the court. Thus, they restrict the balance between the right of individual and the those of the society, as with the rule the between the individual liberty and the social control. All of them are the available against the arbitrary action of the state. However, some of them are also available against the actions of the private individual. Some of them are the negative characters that stabilize the reputation of the authority of the state, while the other positive in nature, conferring certain the privileges of the person. They are the justifiable allowing person to the courts for their enforcement if and when they are violated. They are guaranteed by the Supreme Court, and hence the agreeable person can directly go to the Supreme Court, not necessarily by way of the appeal against the judgment of the High Court. They are not the separation of the permanent government can the certain on repair them back by the constitutional amendment like and not by the ordinary tax. Moreover, this can be done without the affecting the basic system of the constitution. The inalienability of the fundamental right is the instrument in the debate to the September 2. It can be the suspended during the operation of the national emergency except the right guaranteed by the Article number 22 and the 21 under the 6th right guaranteed by the Article number 90 can be suspended only when the emergency is declared on the ground of war or the external aggression, that is the external emergency, and not on the ground of armed elevation, that is the internal emergency. The suspension of the fundamental right during the national emergency is explained in the circumstances system. Their scope of operation is limited by the Article 31A saving of law for providing for the requesting of the stress extra. Article number 31 made the validation of the certain act and the regulation including in the 9th schedule, and the Article number 31 says saving of law the giving the effect to the certain directive principles. Their application to the member of the armed forces, paramilitary forces, police forces, intelligence agencies, and the analysis service can be the restricted or the investigate or the advocated by the Parliament Article number 33. Their application can be the restricted to the material law in the courts in the area. Material law means the military rules that imposed under the abnormal circumstance circumstance to the restore under what are the article. It is the different from the imposition of the national emergency. Most of them are the directly enforceable self-executory with the full effective of them and can be the enforced on the basis of the law and for giving effect to the such the law can be made only by the parliament and not by the state legislators so that the uniformity throughout the country is the maintained and modified. Definition of state. The term the state has been used in the definition or different provision concerning the fundamental right and the article number 12 has defined the term to the purpose of parliament according to the state including the following. The government and the parliament of the India, that is the executive and the legislative organs of the union government and the legislature of the state. So that is the executive and the legislative organs of the state government. All of them are putting that it is the municipality, council, the district, and boards that LIC, ONGC, share extra. Last event has been done in the weather census so as the including all the agencies is the action of is the agencies but can be the census in the court and the ruling the fundamental according to the Supreme Court when as a private body or in the agency working as an distribution of the state force within the maintain of the state under the article number 1. Law inconsistent with the article number 13 declare that all the laws that are the legislative source of the law, that is the custom on the uses having the force of law. Thus, not only the legislation but any of the law can be challenges in the court as the violating is a fundamental right and hence can be declared as violation. Further, Article number 13 declares that the constitutional amendment is not in the law and hence there cannot be the challenges. However, the Supreme Court has in the Keshavananda Bharatiya case 1973 and the constitutional amendment can the fundamental right as a clearances. Right of equality, Article 14 to 80, the consists of equality before the law and the equal the protection of the law prohibition of the discrimination on the ground of the religions, race, caste, sex, or the place of the birth. Article 15, equality of the opportunity in the matter of the public employment. Article number 16, the abolition of the untouchability and the prohibition of it is the practice. Article 17, abolition of the title except the military and the academic. Article number 18, right to freedom. Article number 19 to 22, protection of the sixth right. Protection of the sixth right, that is the freedom of number one, speech and expression, assembly, association, movement, residence, and the provision. Article number 19, protection in the respect of the conviction for offense. Article number 20, protection of the life and the personal liberty. Article number 21, right to elementary education. Article number 21A, protection against the arrest and the detention in the certain cases. Article number 22, right against exploitation. Article number 22 to 24, prohibition of the traffic in the human beings and the forces labor. Article number 23, prohibition of the employment of the children in the factories. Extra. Article number 24, right to freedom of the religions. Article number 25 today. Freedom of the conscience and free profession, practical and the propagation of the religions. Article 25, freedom to the manage religions affairs. Article 26, freedom from the payment of the taxes for the promotion of any religion. Article 27, freedom from the attending religions instruction or the worship in the certain educational institution. Article 28, culture and the educational right. Article 29, 30, protection of language, speech and the culture of the minorities. Article number 29, right of the minorities to the establish and the administration educational institution. Article number 15, right to constitutional reminders. Article number 32, right to move the Supreme Court for the enforcement of the fundamental right, including the right of habeas corpus, the mandamus prohibition, the centenary, and the Kiwa war rando, article number 32. Fundamental right or fundamental right of foreigners. Fundamental available only to the citizen and to elementary right of the minorities to the establishment and protection against the arrest and the detention in the certain cases of prohibition of the traffic in human beings and the forces labor against the prohibition of employment of the children in the factories, extra the article number 24. Freedom of the conscience, freedom of conscience and the free profession, practice and the propagation of the religions, article number 25. Freedom to the manage religions, affair, article number 26. Freedom for the payment of the tax for the promotion of any religion, article number 27. Freedom from the attending religious instruction or worship in the certain educational institution, article number 28. These selections on the ground that in the violates and the fundamental right. Fundamental right that form a part of the basic structure of the constitution and the hence can be declared as prior right to equality before the law and the equal protection of the law. Article 14 say of the state shall equality before the law and the equal protection of law. Article 14 say that the state shall not grant any person equality before the law or by equal protection of the law within the territory of India. This provision confer right on the persons, whether citizens or the foreigners, over the what the person improves the level chartered societies or any other types of the legal person. The concept of equality before the law is of the British origins, with the concept of the equal protection of law has been taken from the American Constitution. The first concept cannot. Number one is the absence of any special preference in the favor of any person. The equal subjection of all the persons to the ordinary law of the land administered by ordinary law court, and no person, whether the rich or poor, uh, high or low official or the non-official, is the above the law. The second concept, on the other hand, cannot the equality of the treatment under the equal the circumstance, both in the privileges conferred and the liberties imposed by the law. That will be the similar application. The concept of the concepts with the latter is the positive concept. However, both of them aim at the established equality of the legal status, opportunity, and the justice. The Supreme Court held that whether the equal and the unequal are the further differently. Article 14 does not apply. With the Article 14 provide class the legislation with the permits reasonable classification of the persons, object, and the transaction by the law. But the classification should not be the arbitrary, artificial, or the evasive. Rather, it should be the based on and the intelligible, differentiable, and the sustainable distinction rules of law. The concept of the equality before the law is another element of the concept of the rules of law propounded by the AVDC. The British jurist is the concept has the following three elements for the aspect: absence of the arbitrary power that is no the man can be the punished except for the branches of law. Equality before the law, that is the equal the subjection of all the citizens, rich or poor, high or low, the official or the non-official, to the ordinary law of the land that administered by the ordinary law court. The primacy of the right of the individual, that is the constitution is the result of the right of the individual as defined and enforced by the court of law, rather than the constitution being the sources of the individual right. The first and the second elements are the applicable to the Indian system, and not the third one. In the Indian system, the Constitution is the source of the individual right. The Supreme Court held that the rules of law as the embodied in the Article number 14 is the basic feature of the Constitution, hence it is the cannot be the destroyed even by amendment, expansion to the equality. The rules of equality before the law is not the absolute, and there are the constitutional and other the expansion or to it. These are the maintenance below the presidents of the Indian and the governor of the state to the following the implementation article 361. The president of the governor is not the answerable to any the court for the exercise and the performance of the powers and the duties of his office. No criminal proceeding shall be the instituted or the continued against the president or the governor in any the court during his the term of the office. No process for the arrest or the enforcement of the president or the governor shall be the issue from any court during his the term of the office. No civil proceeding against the president or the governor shall be the instituted during his the term of the office in any court. The respect of any act done by him is the personal capacity, whether before or the after he the entered upon his office until the expression of the 2 month next after the notice has been the delivered to him. No person shall be liable to any civil or criminal proceeding in any court in the respect of the publication in the newspaper or by the radio or the television of a substantially true report of any proceeding of either house of the parliament or the either house of the legislature of a state. Article number 361A. No member of the parliament shall be the liable to any the proceeding in any the court in the respect of the anything said or any vote given by him the parliament or any committee. Therefore, of Article number 105, no member of the legislature of the state shall be the liable to any the proceeding in any court in the respect of the anything said or the any vote given by him in the legislature or the any committee. Therefore, Article number 194. The Article number 31C is in the exhibition to the Article number 14 is the provided that made by the state for the implementing the directive principle contained in clauses all the clauses number 39 cannot be the selected on the ground that are the violating of the Article number 14. The Supreme Court held that whether the Article number 21C common in the Article number 14 goes out. Foreign sovereign rulers, ambassador, and the diplomat before the criminal and the civil proceeding. The UNO and is certain ground. Article number 15, the providing that not discriminated against the citizen on ground only of the reasons as class sex or the village of the birth. The two crucial word in this provision are the discrimination and only the word the discrimination is to make the adverse discrimination with the regard to or to the distributions unfavorable from others the use of the what only the cannot get the discrimination on other ground is not the prohibited. The section provision of the Article number 15 say that no citizen shall be the subjected to any disability, liberty, restriction or condition on the ground only of the religion, race, caste, sex, or the place of birth and regard to. Number 1, the access to the shops, public restaurants, hotels, and the place of the public entertainment or the use of the mobile banks, parking, hard sport, and the places of the public resort maintained wholly or the partly by state council dedicated to the use of the general public. This provision prohibited discrimination both by the state and the private individual, while the farmer provision prohibited discrimination only by the state. There are the 4 exceptions to these general rules of the non-discrimination. The state is permitted to make any special provision for women and the children, for example, reservation or the provision of free education for children. That is the permitted to make meaning the special provision for women and children, for reservation of seat for women in the local bodies of the provision or the free education for children. The state is the permitted to make any special provision for the advancement of the any social and the educationally backward classes of the citizen or for the scheduled caste and the scheduled tribes, for the example reservation of the seat of free constitution in the public educational institution. The state is the empowered to make any special provision for the advancement of the any especially and the educationally backward classes of the citizen, or for the scheduled caste or the scheduled tribes regarding their admission to educational institutions, including the private educational institutions whether the aid or the united by the state except the minority educational institution. The state is empowered to make any special provision for the advancement of any economical weaker section of citizens. Further, the state is the allowed to the make the provision for the reservation of the up to 10% of seat for such the section in the admission to the educational institution, including the private educational institution, whether it or the united by the state, except the minority educational institution. This the reservation of up to 10% would be into the addition to the existing reservation for this the purpose the economical weaker section would be the notified by the state from time to time on the basis of the family income and other indicator of the economic disadvantage. Reservation for the OBC in the educational institution. In the above the exception C. Exception C was added by the 93rd Amendment Act of 2005. In order to give the effect to his provision, the center enacted the Central Educational Institution Reservation in the Administration Act 2006, providing the quota of 27% for candidates belonging to the other backward classes (OBCs) in all the central higher educational institutions, including the Indian Institute of the Technology (IIT) and the Indian Administration of the Management (IIMs). In the April 2008, the Supreme Court upheld the validity of both the Amendment Act and the OBC Quota Act. But the court direct the central government to the excluded the creamy layer advanced section among the OBC was the implementation of the law. The children of the following the different categories of the people belong to the creamy layer among OBC and thus will not get the quota benefit. The persons holding the constitutional post like President, Vice President, Judge of High Court and Supreme Court, Chairman and the member of UPSC and the SPSC, CEC, CAG and so on. Number 2. Group A Class 1 and the Group B Class 2 Officer of all the Indian Central and State Service and the employee holding and the equipment post in the PSU bank, insurance organization, the universities, etc. and also in the private employment. A person who are in the rank of the colonel and above in the army and the equivalent post in the navy, the air force and the paramilitary force. Professional like doctor, lawyers, engineer, artists, authors, consultant, and so on. The persons engaged in the trade, the business, and the industry. People holding agriculture land above a certain limit and the vacant land or buildings in the urban areas. The persons having the gross annual income of more than 8 lakh or the possessing wealth wealth above the exemption limit in 1993, where the creamy layer selling was introduced. It was 1 lakh. It was subsequently revised to the 2.5 lakh in 2004, 4.5 lakh in 2008, and 6 lakh in 2013, 8 lakh in 2017. Reception for the EWS in the educational institution. The above the exception D was added by the 103 RT Amendment Act of 2019 in the order to the given the effect to in the provision in the central government issue on other in the 2019 providing 10% reservation in the economic weaker section EWS in the admission to the educational institution. The benefit of the reservation can be available by the personnel belonging to the EWS who are not the covered under any of the existing scheme of the reservation for the SC, ST and OBC. The eligibility criteria laid down in this regard is as the follow. The person who is the family has the gross annual income below 8 lakh are to be the identified as EWS for the benefit of the reservation. The income would include the income from all the sources, that is the salary, agriculture business, the profession, extra, and it is the would be the income for the financial year prior to the year of the application. The person who is the family owns or the purchase any on the following the asset are to be the excluded from the being the identified as the EWS irrespective of the family income. 5 acres of the agricultural land and the above. Residential flat of the 1000 square feet and the above. Residential plot of the 100 square yard and above in the notified the municipalities. Resident plot of the 20 square yard and the above is the areas other than the notified municipalities. The property held by in the family in the different locations or different places. Cities would be the grabbed who the applying the land or property holding cash to determine EWS status. Family for this purpose would include the person who does see the benefit of the reservation. These are the parents and the siblings. Siblings belong the as of the 18 years as also his are the exponents and the children below the age of the 18 years. Equality of opportunity in the public employment. Article number 60 provide for the equality of the opportunity for all the citizens in the matter of the employment of the appointment to any office under the state. No citizen can be discriminated against or be the ineligible for any the employment or the office under the state or on the ground of only religions, race, caste, sex, descendant based on the birth or the residence. There are for the exception to these general rules of the equality of the opportunity in the public employment. Parliament can Parliament can Parliament can feasibility resident as a condition for the certain employment or the appointment in the state or the territory or the local authority of other authority as the public employment recruitment as the residence. Act of the 1957 expired in the 1974. There is no such the provision for any state that except Andhra Pradesh and the Telangana. The Assembly to provide for the reservation of the appointment or the post in the favor of any backward classes that is not the adequately represented in the state service. The law can provide that the incumbent of an office related or to the religions or the denomination national institution or the member of the governing body should belong to the particular religions or the denomination. The state is the permitted to make the provision for the representation of up to 10% of the appointment or the post in the favor of any economical intersection of the citizens. This the reservation up to 10% would be the addition to an existing reservation for the purpose the economical intersection would be the notified by the state from the times to times on the basis of the family income and other indicator of the economic disadvantage. Model Commission and the aftermath. In 1979, the Morarji Desai, the government appointed the second Backward Classes Commission under the chairmanship of the B.P. Mondal as a member of the parliament in the term of the Article 304 of the Constitution to investigate the contribution of the social and the educationally backward classes and the suggest measure for their advancement. The commission submitted is the report in the 1980 and identified as many as the 3,743 casted as the socially and the educationally backward classes. They consist nearly 52% component of the population, excluding the scheduled castes, SCs, and the scheduled tribes, STs. The Commission recommended for the reservation of 27% government jobs for the other backward classes, OBC, so that the total reservation for all the SC, ST and OBCs amount to the 50%. 50%. It was after 10 years in 1990. That is the EPC government declared the reservation of the 27% government jobs for the OBCs again in 1991. The Narasimha Rao government introduced two census The Nashima now is a true sentence. A is a preference to the poorer section among the OBC in the 27% quota, that is the adoption of the economical criteria in the granting reservation. Number B is the reservation of the another 10% of jobs for the poorer economical backward section of the higher caste who are not covered by any existing schemes of reservation. In the famous Mongol cases, 1992, the scope and the extent of the Article 16(4), which provides for the reservation of jobs in the favor of the backward classes, has been examined thoroughly by the Supreme Court. Through the court has rejected the additional reservation of the 10% for the poorer section of the higher caste. It upheld the constitutional validity of the 27% reservation for the OBC with a certain condition applies. The advanced section among the OBC, the creamy layer, should be excluded from the list of beneficiaries of the reservation. No reservation in the promotions reservation should be confined to entail appointment only. Any existing reservation in the promotion can continue for the 5 years only, that is up to 1997. The total reserve quota should not exceed 50% except in some extraordinary situation. This rule should be applied every year. The carry forward rule in case of the unfilled backlog vacancies is valid, but it should not violate 50% rule. A permanent statutory body should be established to examine the complaint of the inclusive and the under inclusive in the list of OBC. With regard to the above the ruling of the Supreme Court, the government has taken the following action. The Ramanathan Committee. The Ramanathan Committee was Ramanathan Committee was appointed to identify the creamy layer above among the OBC is submitted is the report in 1992, which was accepted. National Commission for the Backward Classes was established in 1995 under of the Parliament. It is the mandate was to examine the competition of the under inclusive over the inclusive or the non inclusive of any classes of the citizen in the list of the backward classes for the purpose of the job reservation. That the 102 Amendment Act of the 2018 conferred the constitutional status of the Commission and also the the functions for this purpose. The amendment inserted as a new article 338B in the Constitution in order to clarify the ruling with regarded to the reservation in the promotion the 77th Amendment Act was enacted in the 1995 as a new provision in the consistent than the required by the state for the provide for the reservation in the purpose of any service under the state in the favor of the Supreme Court and the state that are not the adequately respected in the